네, 종합 토론을 함께 즐기시다가 혹시
If you have any questions while listening to the panel discussion, please go to YouTube. You can just type in the title of today's forum to search for the live streaming, and then you can post a question in the reply section of the YouTube or review section of the YouTube. So please, we look forward to your participation. So I think we have done arranging the stage once again. We're now going to start the panel discussion, and I'm now going to give the microphone to Professor Kyung-Shin Park, Professor of Ewha Women's University.
네, 안녕하세요.
So thank you for being with us for a whole day. So I am the moderator for the panel discussion. My name is Kyung-Shin Park. So it's really difficult participating for the entire day, and usually the panel discussion is preceded in a nearly empty hall. But we see a full hall today, and I think that shows the level of interest towards metaverse and the IP-related issues. So we have experts from Korea, and from abroad, and they have raised a lot of issues. Actually, I think they've raised all of the issues possible in regard to metaverse. They have talked about the markets and the legal system, and so I'd just like to thank the presenters once again. So we've been talking about issues, the design rights, trademark, the redundancy protection and the digital twin, copyright. So I think we have touched upon more or less all of the different issues related to metaverse. And we do have a time limit. So I think as a moderator, I will have to select some questions and we won't be able to entertain all of the questions. But anyway, we have looked at the legal systems in different countries. They're all different according to the jurisdictions. And there are some abstractness of the legal system in relation to the metaverse. But nevertheless, I think if you listen to the presentations, there were some common traits. For example, there was a matter of jurisdiction. So when it comes to design and trademark and also industrial property, there's the territorial principle that is applied. But on the other hand, the metaverse platforms are multinationals. And so when there are disputes and violations, international law has to be applied to these areas of the metaverse. And so today we'll be talking about ways forward for the international cooperation in order to deal with the disputes in the metaverse. So the Web 2.0 disputes are very different from the disputes that are being raised in the metaverse. And so first of all, I can ask the presenters if you have any questions you'd like to ask of other fellow presenters, you may go ahead. And also, if you have any suggestions for some other topics that you want to discuss in the discussion panel, please go ahead. Professor Han, I think perhaps would you like to go first? Hello, my name is Chi Young Han. So, the IP and metaverse related issues have been raised quite comprehensively, and they were really challenging issues that we're facing here. In particular, when it comes to IP and industrial property, they are quite different from one another, and that well, actually, the copyright is based on the Berne Convention, and there's a principle of non-formality, so you don't have to register to have your copyright protected, but industrial property can only be protected after examination by organizations like KIPO, and you have to be able to register your right to be guaranteed those rights. But in Europe, you have unregistered designs that are also protected. So then, for example, if in other countries you would have unregistered designs and they will not be protected, but in Europe they will be protected. And then you have the differences in law. And if there is a metaverse related dispute, then what happens then? Because there are differences, and that leads to the issue of the jurisdiction. So, for example, if you look at the Korean Metaverse platform, you have unregistered design from Europe, and it's used unauthorized. And then, is it violation or not? And then, conversely, you'd also still face the challenge of having to determine whether it's a violation or not, according to which jurisdiction and which law. So, the
발표를 해주셨는데 상당히
you have the private international law, and so you have come up with the 7 solutions. So, but can we apply it as they are to the metaverse? So that's another question that we need to deal with. So basically, the WIPO does have to play a certain role as an international organization that has a mandate over these issues. And we have also heard from Mr. De Castro about the arbitration and the mediation process. Anyway, the treaties, forum, and arbitration, these kind of procedures are going to become increasingly more important.
Thank you very much. That was sort of a general summary that stressed the importance of international cooperation rather than posing a question. Does anyone have anything to add to that point among the presenters? If not, we'd like to make this a little more interesting, and there's a question that came up on the YouTube chat feature. Perhaps we could discuss this question. So this question goes to Professor Kyu-ho Lee. And in your presentation, you were talking about the terms of service that were provided by Naver. Even if there's agreement on exclusive choice of court, but choice of law could be determined differently from choice of court. Perhaps we could address that question before we going on with another discussion. My name is Kyu-ho Lee, not Ki-ho Lee. But anyway, to look at the terms and conditions of the Zebeto of Naver, there is the international choice of court agreement, but applicable law has not been determined, it's not stated. And if the applicable law is not specified, then according to private international law, the most closely related relevant law would be applied. And I think that was rather a matter-of-fact question. So private international law, this entire idea is rather difficult to understand, and perhaps that's where the question came from. So if we could turn our attention towards more progress on the international cooperation, we have probably a panelist from WIPO Arbitration and Mediation Center. So Professor Han earlier was touched briefly upon the role of WIPO, and WIPO has been speaking about digital copyright and content-related disputes. And regarding Metaverse, as was mentioned earlier, digital content disputes perhaps might be a little different from the way we should approach a Metaverse-related disputes. Do you have anything to say on that?
If I may, 제가 먼저 시작해도
So can I just start? Is it okay for me to start?
네, 발언 기회를 주셔서
Thank you very much for giving me an opportunities to speak. My name is Adam Kwan. I'm a lawyer, but I am also working in the WIPO Arbitration and Mediation Center. So, Ignacio de Castro, who is the director of our center, spoke in session 3, but I am participating on his behalf. So I was able to get a lot of insight from a lot of the presentations that were presented today. And so what I want to share with you today is the fact that the laws in all countries are very much different. But then in areas like Metaverse, where new technology is applied and there is an international dispute that is raised, there is a very cobweb of complex issues. And so we have arbitration and mediation based on the interests and rights and obligations of the parties involved. And this is the service that we provide at the center. So we're an international organization, and the member countries are promoting international cooperation. So in that regard, see the fairness and the international neutrality and independence are some of the principles that we believe are very important for us. And if you look at the ADR services provided by the WIPO, one of the biggest advantage of our service is confidentiality that we provide. And when it comes to IP, confidentiality is particularly important. And also in a digitalized environment such as the metaverse, the disputes have to be resolved very speedily. So that's also quite another big beneficial aspect of our services. And also security is another important principle. So just to share a little bit of an experience, during the last 2 years, during the COVID-19 pandemic, our arbitration and mediation have gone entirely online, or sometimes in a hybrid fashion. And in regarding what Professor Kyu-ho Lee had mentioned, when it comes to the similarity and the homogeneity of identity, I think we can make use of the blockchain technology. We can use the blockchain technology, and I think it's a very interesting topic they just raised there. Thank you. Thank you very much for your response.
So in terms of metaverse, if we look at it, it's also digital space, and the dispute resolution frameworks for digital content that have already existed may be useful. But at the same time, if we look at the specific characteristics of metaverse, perhaps the arbitration frameworks or ADR systems, is there anything we should consider or improve to better deal with issues regarding the metaverse? Would any speaker care to address that question? If not, so dispute resolution systems are very important, but at the same time, what has been discussed extensively in the past, and a lot of the speakers have been touching upon the terms of use, unfairness, and just compensation issues. The opinions that keep arising is perhaps providing a more standardized terms of use for metaverse platforms. Perhaps this effort could be spearheaded by WIPO, because there's a lot of demand for that and there are a lot of issues arising. For example, if a standardized metaverse platform terms of use, how effective would this be in actual industry? Perhaps I could ask this question of Mr. Shane O'Reilly, who is in the industry himself.
Yeah, this is Shane O'Reilly. I think standardized terms of use. I think it's helpful, but I think it's ultimately something that would have to be done in partnership with the technology companies that are building the metaverse. Because I think, frankly, even if Meta partnered with other companies to build terms of use, I think that's a difficult enough process. Because if you look at the terms of use for our Horizon Worlds platform and for our device, and you look at the terms of use for Decentraland and Sandbox, there's not a direct alignment. So I think it ultimately just requires really much more coordination around with the companies around just kind of what standard terms we want to include as a bare bones position. And maybe, maybe an idea is we highlight those areas that are less contentious or that companies are less likely to argue about. So it might even be around, ownership of IP, among the creators. Maybe that's something that's less likely for the owners to argue about. Or maybe it's something similar to dispute resolution. We kind of all agree that any disputes associated with the metaverse should be within a specific jurisdiction or location, or that it should go to arbitration. But I think I think it would just take just companies coming together and figuring out which provisions we could all agree on, maybe even working with WIPO on that, and then going from there.
Thank you. So actually, I just gave you a very abstract question, but thank you very much for your detailed answer and concrete answer. So anyway, the terms of use for the metaverse platforms cannot just be limited, or the standardization cannot be done by just one country or one company. And so there are also various types of metaverse. So we also have to take into account the different types of metaverse. So regarding this question, the terms of use for the metaverse platforms, anybody else would like to add anything? So I have actually a question. So metaverse service providers' terms of use, have there any related disputes being tabled at the WIPO Arbitration Center? So I think Adam Kwan, or maybe the director, can answer from the WIPO Arbitration and Mediation Center. So he was asking the question, have there been any cases related to terms of use of metaverse platforms? So perhaps can you elaborate on that?
I think that's one for you, RM.
네, 안녕하세요. 질문
Yeah, thank you very much for that question.
플랫폼 플랫폼 사업자에 관해서
So regarding platforms or service providers,
분쟁 사건이 저희 중재조정센터에 회부된 사례가
so the
있는
question,
걸로 알고 있는데
yes, I do know that there has been a case that has been referred to the arbitration center.
앞서 언급드렸겠지만 기밀성 관련된
But then I did mention confidentiality, so I cannot mention the details about the particular case.
하지만
But what I can say is that we did a survey,
최근에 디지털
and recently,
문제에 관련된
regarding digital disputes, we did do a survey, and if you look at the results, you can see that
간략하게 정리해가지고
there is a brief summary of the different cases that have been submitted to our center. So if you actually refer to that report and the survey results, you'll be able to see some cases there.
그리고 관련해서 더 자세한 사항이
And if you want further details, or if you actually
발생해서 저쪽으로 문의 주시면
want to submit an application for mediation, then we'll be able to give you a more detailed response. Thank you.
어떻게 보면
So this answer just now, alternative dispute resolution, ironically enough, that answer highlighted the strengths of the ADR because secrecy is guaranteed, and for new platforms, new technology platforms like Metaverse, the trade secrets are very important. So those ADR mechanisms that guarantee secrecy could be very attractive indeed for the industry. So I have a question. So in the terms of use, if there's a dispute that arises, if arbitration takes place, it's a one-time decision. And if the businesses are the parties, then things can be very unfavorable towards them. So parties who desire going to 3 times, they might want to go to a lawsuit to the court rather than arbitration. So perhaps Mr. O'Reilly could take that question.
Yeah, and I think that's, look, I think the reality is, I think that's probably more of a kind of case by case basis. I think, certain companies might ultimately have a preference for there to be a lawsuit as part of their terms of use as opposed to in ADR. So I think it ultimately just kind of comes down to a business decision. But I think that's a very interesting question that you raised, and I think pretty interesting issues that would need to be grappled with and worked out. Like I said, should there be some type of standardized terms of use that companies agree on?
네, 뭐 사실 이제 뭐 저희가 뭐
So ADR is actually one of the many alternatives. I think there is a question from YouTube or from the floor.
저희 그러면 그 토마스 딜런 법률 고문
So I think, Mr. Dillon, you said you wanted to say something earlier, I think.
Yes, I just wanted to make a couple of short points about ADR. Clearly, ADR, especially the ADR provided by WIPO, is a potential workaround for jurisdictional questions. But I think we need to remember that the international infrastructure for enforcing arbitration awards applies only to international and non-domestic awards. So ADR is not going to be necessarily not necessarily going to provide a uniform solution for domestic cases, because the New York Convention applies only to non-domestic cases. So that's a small, rather academic point. The second point, which is more practical, is that it's fine for industries to develop a consensus about terms and conditions, but the terms on which they do business are a potential competitive advantage for them vis-a-vis the market. And as the music industry found when it tried to respond initially to the threat of online piracy, if you try to agree business models within an industry, you immediately run into problems with the competition regulator. So industry, I think, will probably be very nervous about progressing towards uniform terms through agreement. They probably have to simply compete, and the consumer will determine which terms are most acceptable.
네, 이렇게 추가적으로 또 저희 메타버스 플랫폼
So, yes, we've been talking about the terms of use in relation to Metaverse platforms, some of the challenges and concerns. So when we talk about jurisdiction, whenever we run into the issue of jurisdiction, a solution is an international treaty or international convention. So regarding the Metaverse platforms, some people say that we need a convention and treaty, but that's not going to happen overnight. But it does come up. But it could be a new treaty, or it could be an addition to an existing treaty. But anyway, there needs to be some kind of an international treaty or law on Metaverse platform. So anybody else have something to say about this international treaty or convention or possibility of one regarding the Metaverse? So perhaps we could give the mic to our speaker from the European Union, because you have many members and it's the European Union. So perhaps Mr. Ververdorfer, do you have something that you'd like to add regarding the possibility of an international treaty or convention or agreement regarding the Metaverse platform?
Very much also for the contributions of everybody here today. It was very interesting for me and a pleasure to listen to you. What was mentioned before, and that potential infringements will affect basically all the countries of the world and all IPR rights, including unregistered designs in the EU. This is certainly correct. As long as the territoriality an infringement is confirmed in that area. So this is, of course, the situation. And even more listening today, I found interesting and, of course, very valid that one of the main legal basis which will be used, I assume, in the future will be unfair competition law, meaning not IPR instrument, but unfair competition law. And just to mention in this regard that within the EU, we have not harmonized this. We are not able to harmonize this because this is very differently regulated. So this even adds to the problem. And as you referred to the experience in Europe, how far we are able to harmonize our legal framework, it shows the difficulty. Of course, it would be very helpful to have international treaty or convention, maybe even an amendment of TRIPS, WTO TRIPS, but seeing the international tension about TRIPS, I see this as very difficult at the moment because interests are very much disaligned, I would say. So it would be very good, but I think difficult. I mean, to be worked on probably with the help of many partners to get it moving. Maybe if I have two comments as well to the ADR system, which would be certainly a good way out of this, but to be remembered, both parties have to agree on the ADR process. So this has to be achieved, and it's not always the case. Secondly, there will be a limitation in the amount of cases which the WIPO will be able to deal with. So I repeat a bit what Shane said today. I mean, twice. First, to say that to be seen by the platforms a bit what is really a damage or maybe a promotion, to distinguish maybe more between small, more or less innocent users and really the big wrongdoers, and have maybe a different attitude towards the virtual world compared to the real world. I think this might be a tendency, but of course I'm not in the business, but I would assume this might be the case. Yeah, that would be my take.
저희 공사 참사관님께서
So, Mr. Vervendorfer raised a question that actually necessitated today's forum. And amongst the presentations, Mr. Masuda talked about the NFT white paper in Japan. And it's symbolic, but at the same time, I think that kind of effort on the part of the Japanese LDP actually formed a basis for international consensus. So could you maybe elaborate on this international aspect or international potential of the white paper, Mr. Masuda?
And thank you for presentation then. As for the white paper published by the LDP, they are partially concerned about the international issues, like including the standardization, the metaverse rules, but it mainly focused on the technological and also the construction of the service measure, like controlling users' usage of the service or the like that. So including by using blockchain technologies or by using some storage services or other aspects of infrastructure or some kinds of such basic issues for the establishment of each services. So currently they are not concerned about the dispute resolution, but it will be. And in another aspect of white paper, they are really discussed the consumer protection issues regarding NFT trading or crypto trading. So in the next white paper, it will be amended at this year, at the end of this year or the next year, and probably such consumer protection issues regarding the dispute resolution will come in the next version.
네, 최근 사실
Actually, recently, the platforms like NFT and Metaverse, of course, you have the protection of the rights holders, but also the protection of consumers is another very important issue. So Mr. Hee-Chang Kim and Professor Changhwa Kim have been talking about the copyright and industrial properties like trademark and design. So perhaps there's something you would like to mention because you're running out of time. You could not mention in your presentation, or is there something else you would like to talk about regarding to international cooperation? Now is the time to go ahead. So actually, I have a question for Professor Changhwa Kim. So
What you mentioned earlier about expanding the scope of Design Protection Act to better protect the items within Metaverse, and you also talked about the importance of harmonization with the Copyright Protection Act. But my concern is that in addition to the issue of protection within the Metaverse, we should also be concerned about the issue of free use. So Copyright Protection Act and Design Protection Act, if they are working together, areas that are allowed by Copyright Protection Act, how will protection be additionally provided by the Design Protection Act? Yes, that is indeed a very difficult issue. When I was studying Design Protection Act, whether better protection for design actually affords more protection. So IPR in general, the ultimate goal is not to protect the rights of the right holders, but to further develop the industry. So of course, the free use is a very important issue. If we look at reports from the United States, there's also such content. So US patent law, if that protects design, then it might actually hold back innovation. So that is one sentence that I saw in a report from the United States, and I actually agree with that statement very much. So if digital design is brought under the realm of Design Protection Act, from a realistic perspective, of course, we're discussing this because there's the urgent need for protection of digital designs. But in terms of free use, if something is allowed under Copyright Act, if that is, again, blocked or prevented by Design Prevention Act, then that would be a problem. So that has to be taken in consideration when we're amending the acts. So in terms of protection of IPR, we think about the right holders protection, and we also look at the collision with the basic rights such as freedom of expression. And we had a question from the floor.
버추얼 인플루언서가
So there might be not for sale clothing, in other words, 3D digital clothing that is worn by a virtual influencer. And this clothing might have a logo or may have copied the clothing of somebody else. So would that be considered as an infringement of IP? So these kind of 3D digital clothing is not for sale, but nonetheless, the virtual influencer may be wearing this across the different media. So could that be a problem? So that was a question for Professor Han. So thank you very much for the question. And I think it's a question that can come quite frequently from the users. So there's the Article 2 in the Trademark Act regarding the use of the trademark. So just having that mark is considered as using a trademark. So whether the clothing is for sale or not for sale, just the fact that the logo is there on the clothing can be seen as an infringement of trademark. But then what happens in a virtual world? So that's one question that we need to think about. And then the clothing is not for sale. That's a second issue. So in the case of a not for sale clothing, how does the how does the Trademark Act consider this fact? Well, actually, in the case of patents, there is a criteria about the commercial use, but we don't have that kind of provision in the Trademark Act. So even if it's a non-for-sale clothing, if it was used by a business, then it would be considered a violation of the Trademark Act. In the case of 3D digital or virtual clothing, is that a product under the Trademark Act? That's another question that we have to deal with. In the case of virtual products, as I had said in my presentation, can be categorized under number 9, class 9. And so even if it's for non-commercial purposes, it can be actually infringement of trademark, because even though it's virtual under class 9. And then the fact that it's non-for-sale clothing. And if it was actually copying somebody else's clothing in the virtual world, would still that be a violation of copyright or IP? Well, the design of clothes is also copyrightable. It can be considered as an artistic or a photographic work. And then it could also be considered as the audiovisual work if it's actually also visual as well. So yes, they are copyrightable. So in the metaverse, if you have this kind of copying of clothes, that can also happen in the real world. Or if the clothing in the metaverse had copied something in the real world, then it can actually consider be a violation of copyright, because it doesn't really matter if the purpose was commercial or not. So in fact, there are many users of the metaverse, and they have a lot of questions, I think, and one of which was just entertained. But unfortunately, due to the time constraint, we do have to wrap up the Q&A and the discussion session. So from the morning, we have been talking about the metaverse market, relevant laws and regulations, and it was, I think, a very meaningful forum. So I would like to particularly thank the presenters, and also I would like to thank all the participants for being here with us until the end. It's been a long day, but I think we still need more discussion. And so hopefully the Presidential Council on Intellectual Property will probably come up with another session for us to continue our discussion. So with that, I'd like to close today's Global Forum on IP and Metaverse. Thank you very much. Thank you, everyone. As she has mentioned, we've been here for quite a long day, but I'd like to thank Professor Kyung-Shin Park once again for moderating the session, and also all of the presenters and the participants in today's forum. With that, I'd like to announce the end of the Global Forum on IP and Metaverse, organized by the Presidential Council on IP and MCST and KIPO. Thank you very much for being here with us for the entire day. Have a safe trip back home. Thank you very much.